We got the best presentation last, so. Yeah. Oh. Okay, we'll get going here. Most of you know Sean. Sean Fredricks is a lawyer with Ohnstad Twichell, and he is a shareholder. He practices water law exclusively, and he represents several water resource districts and rural water systems in North Dakota. He has 20 years of experience. He is a leader in water in the state, and he appreciates his relationships with other water leaders and boards throughout North Dakota. So please help me welcome Sean Fredricks.
Thanks, Jack. Did Ben leave already? Mark had asked earlier why Cass County has more than one water resource district, and Ben and Jeff Frith, is Jeff here? They're both gone. They were thinking it's some kind of conspiracy that I concocted so I could build more water resource districts. So I wish I could take credit for that. Although it could have been Manfred Ohnstad and Dan Twichell. They were around when that happened. But anyway, so first of all, thanks to you guys, water managers. Jack mentioned earlier the water compensation bill that went through this session, and I was very pleased to see that go through. I tell water boards that I work for that, and you know, one of the things that you guys do as water managers, a lot of guys will say, well, I was only on the phone for half an hour and then I just drove out and checked on a drain or something. I'm not going to mark that down as a per diem, or, you know, and I always get after guys for that because I always feel like you guys are so underpaid. It's ridiculous. Do not shortchange yourselves. Make sure you're marking every per diem, you know, and so I'm glad to see that you got some kind of raise, even though I still feel like you're incredibly underpaid. You guys do a lot of good work. It's obviously not for the glory, as you know. It's not a springboard for a political career, as you know. So thanks for all the good work you do. Also, thanks to North Dakota Water, Jack and Danny and Julie just do unbelievable work. And I see it firsthand. I'm on the legislative committee and I work with them. Well, during the session, every day we're in contact. And then throughout the year, we're in contact. And I see the work that they do. And I don't think everybody understands the amount of work that they put in. You know, sometimes they'll show up at a meeting at 6:30 during session, especially they'll have some 6:30 a.m. breakfast meeting, and they'll still be doing a Zoom conference at 10 o'clock at night. So the amount of work that Jack and Danny do is pretty incredible. In fact, let's give them a quick hand if we could. Seriously, they do great work. So thanks to Jack and Danny and Julie for all the good work you guys do. I don't know if Jack's Fig is still here. Put this in just for him. So anyway, oh, there he is. Hey, Rich. All right, let's get going on some tile. I was thinking about this morning. By the way, all the presentations have been really strong today. So thanks to all the other presenters. Just really good information today, I think. I was thinking this morning about this tile permitting stuff, and I can remember the first tile project that I ever heard of, or the first time I really kind of learned about tile was, I want to say it was in 2005. Dan was on the Sargent County Water Board, and we used to meet at night in the courthouse in Foreman. And there was a landowner down there who started tiling a lot of acres, and it was Max Fuchsa, for one of Levi's predecessors for Ellingson. And we're all learning about it, trying to figure out what's tile, what is it? Literally, we were trying to figure out what it was. Second, the board's asking, what do we do with this? do we need a permit? What do we have to do with it? So, and there wasn't a statute specific to tile. I didn't really know much about it, so I called the state engineer's office and we kind of talked through it, and we sort of agreed that, well, I guess you got to use the permitting statute we have for surface projects. So just use that. And all right, well, that's what I'll do. So we went back and we're sitting out in meetings at the courthouse. And the surface permitting statute, as a lot of you might know, one of the things that it says is you have to examine downstream impacts as part of your analysis for a permit. And it still reads that way today. And if your investigation reveals that there will be adverse impacts downstream, you have to require a flowage easement as a condition to your permit. So that's in the surface permitting statute. At the time, there was no tile statute. So we had to apply that to tile projects. And so we're trying to figure out, are there downstream impacts from tile? And it was Chad Engels was the board's engineer, and Chad studied that and went and researched and contacted the University of Minnesota and things like that. Hans, I forget Hans' name, but yeah. And so, you know, we're doing all sorts of, water managers were doing research, we're trying to figure out, all right, are there impacts from this? Well, there could be a, heightened level of saline and et cetera, and maybe there's more water downstream. It's hard to tell. We just don't know yet. And so the statute said if there are impacts, you've got to require easements. And we talked through this as a board, and the downstream landowners, by the way, would be into the board also. So we had the landowner on one side, we had Max sitting there with them, and then we had the downstream folks. And Max is saying, give my client his permit. And the downstream folks are saying, you can't just give him his permit, he's gonna drain on me. So, you know, Dan and the board's looking at me, well, what do we do? Well, we have to decide if there are impacts downstream. Well, we think there might be for a little ways. Okay, then you gotta require an easement. And a lot of you remember all this. And so we started, okay, well, let's approve this one. But as a condition, you gotta get an easement, you know, however far downstream. And that really ticked off Max, obviously, because we had sort of Hatfield-McCoy issues happening, right? Downstream landowners were coming in complaining about these projects, and we couldn't quite tell if, are there really gonna be impacts, or is this the downstream guy hates the upstream guy? I mean, we're in the middle of these things. And I literally one time had at a Sargent County Water Board meeting, it was about midnight, because we debated one of these things for a couple hours. At the end of that meeting, the board required an easement from a downstream landowner. And one of the applicants, I believe it was his son, he told me he'd be waiting for me with a shotgun outside when I walked out to my truck. So he literally said that. I sort of laughed. I thought I was a tough guy and didn't think anything about it. And then I told my wife about it later, and she wasn't too happy. But you know, so that was the first application that I remember. And from there, we had to figure out how to do this. And the Attorney General issued an opinion saying, well, yes, you have to use the surface permitting statute. Then later in 2011, some of the legislators started to feel like, well, this easement issue is becoming a problem, right? Because again, it's pitting landowner against landowner, neighbor against neighbor, Hatfield against McCoy. And so Phil was in the legislature then. He'll remember that bill. And that was the first tile statute was passed. And I remember being in the hearing. Wes Belter was one of the primary sponsors, if I remember Phil. We were in one of the hearings, the committee hearings, and we were talking about this downstream issue. All right, what do we think? Does it cause impacts? And Wes is saying, I don't think it does. And other folks are saying, I can't remember if there was some road authority or somebody was saying, no, there are impacts. And Wes turned to me and said, well, what do you think about, what if we say you can require an easement, but only 1 mile? And neither of us had any science behind any of it. We just said, okay, that was a negotiated deal. We said 1 mile. So there was still an easement requirement after 2011 for downstream impacts. That still wasn't working because you still had your Hatfield-McCoy thing. And so we've gone through a few different versions of tile permitting statutes over the years as we've tried to figure this out. And I think early in the process, water resource districts were sort of in the middle of it all, because we felt like, when I say we, I mean the water managers, we felt like we support tile. We think it's important that we have a rational and reasonable permitting statute. At the same time, we had downstream interests coming to us and saying, well, look, you can't just approve these things because they're going to be dumping on me and I'm going to get saline, et cetera, et cetera. So we had all these people, coming at us from both sides. In the legislature, we were sort of viewed as, I think, maybe we were impeding progress, I think is what people thought. Well, look, you're opposing tile. Well, that wasn't the case at all. We were just saying we support tile. We just, we're hearing from the downstream people and we have to represent them as well. And so it's sort of a nuanced position, and it wasn't an easy position to try to explain to folks. And I think a lot of legislators and other interests started to think, well, you guys are opposed tile. That's not the case. And so early in that process, I think lines and divisions were formed, and that was not helpful, right? Because I think a lot of us wanted to get to the same place. And over the few versions of tile permitting statutes we've had, there were big fights that developed. And again, water resource district managers, we were sort of viewed as opponents, and that just was not the case. And so the nice thing about what happened most recently, this last interim, Representative Schreiber-Beck, who is obviously a legislator, she's also a landowner in Richland County. She had a tile project that she was doing on her own property, and she has a good relationship with Monica Zentgraf. She's the Secretary Treasurer for the Richland County Water Board. And Monica's down in the trenches, I like to say. I do a lot of permits, right, for a lot of water boards. They get them, they send them to me, hey, you write this up, figure out what we need to do, what do we need to require. Monica does a lot of the trench work. And she was working through some of these things, some of these issues with Cindy. And I think it really helped Cindy realize that there are a lot of issues at play here, right? We got downstream interests. We got the permitting process that at the time required a 30-day notice. Well, what is this purpose? What's the purpose of this 30-day notice? Is this serving anybody? There are downstream road authorities, right? There are tile contractors who have their clients behind them saying, look, we need to get that tile in, right? And so you have all sorts of different interests, and Cindy was seeing all that. And she said, look, let's bring everybody to the table. Instead of early on, it was pitted as Levi and Ellingson against water managers. And I'm really glad that Cindy brought us all to the table through Monica, because we were able to sit down with Levi and with Kale and with Roger Ellingson and Derek and explain, I think we have more in common than you might think. And that's really what turned out to be the case. We didn't have that many differences, really. And this was a really good process. We took months to do this, and we hashed through, all right, what's our bullet point? What are our bullet point issues? What do we need to have done on our side? What do the contractors want to see? Levi went out and talked to some of the ag groups to find out, hey, here's what we're talking about. Does this make some sense? So it was a months-long process, and we tried to survey a lot of different interests. And I think that's how you generate a bill that, when you're addressing something that could be that controversial, because all the previous tile bills had been so controversial, this was a good way to get something done and get it done in advance, so that we're not in the legislature at a committee hearing where you've got 50 people lined up to testify, and again, divisions are forming. Instead, Cindy brought us all to the table, and we started talking through what our perceived differences were and started to realize there really weren't that many. And I think we all agreed that we could make this, next slide here. We could make this a more efficient process. We could make it a process that's beneficial to landowners and tile applicants, tile contractors. And we could also still do it in a way that would protect, in a reasonable way, protect downstream interests. Not in a way where you're pitting Hatfields against McCoys, and you're requiring easements and things like that, but in a way that's sensible where water managers are still involved. And I think that's your job, right? And you guys are the ones who do this and do it well. And I think having you as sort of a mediator in a lot of these situations is the best case scenario, as opposed to saying, all right, here's your permit, now go fight with your neighbor about whether or not he's gonna give you an easement. Or here's your permit, downstream guy, you sue your upstream neighbor. You know, those aren't good outcomes for anybody really. And so anyway, it was a good process. I've been through a lot of legislative sessions, and this was the most rewarding process I've been through. Now at the end of it, I don't think any of us sat there and felt like I got every single thing on my list that I wanted. But you know, that's how negotiations work, right? And at the end of it, I think we all felt pretty good about the outcome. Now, we had to make some modifications during the session and some concessions, but I think Cindy was pleased, Representative Schreiberbeck was pleased, and I think most of the ag groups were happy with the outcome, I hope. I know the water resource districts, hopefully after we talk about a couple of things here, hopefully you'll feel like we got what we needed, and I think the Ellington folks felt like, yeah, this turned out all right. So it was a good process. And again, the idea was let's do this in advance. It's a novel idea, right? Do this in advance on a controversial issue so that we're not in committee rooms arguing about it. Oh, yeah. So as most of you probably know already, HB 1437 was passed. It had an emergency clause, so it's now the law of the land, right? That went into effect when it was filed with Secretary of State's office on May 3rd. So this is the permitting regime that we're dealing with now. So if you're not aware of that, well, I think Jack sent out notices on a lot of this stuff, and even sent out some of my sample documents. Use them if you want, make up your own if you want. But at any rate, that's how we're operating now. Oh, this last point here, that's been a point of contention, you know, since whatever, 15 years ago, that water resource districts are doing this differently. And I think the point that Levi made, for example, when we talked was, look, we're getting one thing from one water resource district, let's say from Arv and his board, and then we're getting something completely different, you know, 200 miles to the west at X water board. They're doing something completely different. And I think that's a fair criticism. You should have a pretty good idea of how these things are gonna function, right? How the permitting is gonna operate. And most boards should do it in a pretty similar fashion. And the idea under these statutes is, look, here are the conditions that you can attach. That's it. And so with that in mind, we should be operating in a pretty similar fashion. And so I think the communications from Jack and Danny's office have been, here's the bill. This is how it passed. You have to operate under this bill. Here's some sample documents. Like I say, you don't necessarily have to use mine, but they give a roadmap of how you should be doing it at the very least. So we do not want to be in a situation where a particular water resource district is out there doing things differently, maybe not approving permits, or maybe they're sitting on them for 3 months. That will result in us being back in the legislature and probably the elimination of permitting for tile altogether, right? And maybe some of you think that's a good idea. I don't know. So far, water resource districts have felt like we should be permitting these things so that they're done in a reasonable fashion. So I guess my point is, let's figure out a process. And if you can take my process and improve it, that's great. But let's figure out a process and let's all do it, okay? We don't want to have one water resource district doing things differently, because we're going to end up back in the legislature. I should have worn my glasses here, sorry. Let's see. Okay. The permitting threshold, as Levi noted earlier, it's still 80 acres. Okay, so that's been the case for years, right? Basically, even under the surface statute, 80 acres is still the permitting threshold. Oh, there's a clarification in this bill that the idea is this only applies basically to ag tile, right? I think Senator Luke maybe had a situation where one of his constituents was tiling homestead parcel or something like that. And Arv, you can correct me if I'm wrong, if this is ringing a bell. I think there was somebody in Richland County who was maybe tiling a homestead or something like that and didn't feel like that should be permitted. And we agree. Yeah. Okay. Yeah. So yeah, the idea is this is for ag purposes, right? That's the purpose of a tile permit. Surface inlet. Oh yeah. Hey, Ben.
The 80 acre piece, can they pattern tile the 80 acres? Or is it a watershed that feeds that?
Oh yeah. So the question is, are you talking 80 acres of tile or the watershed that drains into it? Yeah, good question. So under the surface permitting statute, it's the watershed area impacted. So it might be a very small project, but if you're draining 160 acres, but it's through one small little project, the size of the project doesn't matter. It's the watershed impacted. For tile, you're talking 80 acre footprint. So yeah, that's a good distinction. Good point, Ben. One of the things that came up, I think it was in the 2017 bill, was surface inlets. And I think, if I remember correctly, it was a 3/8 or smaller surface inlets on a tile project would be permitted exclusively under the tile statute. Well, this last bill eliminated that. And so all surface inlets, if it's a tile project, even if it has a large surface, couple, larger surface inlets, it's still under the tile statute. Now, I know the state was a little concerned about that in terms of statewide interdistrict significance type projects. And I think the state felt like, well, that those should probably still be permitted under the surface statute. So it'll be interesting to see how this sort of unfolds. I know Levi had some data that sort of suggested that, look, first of all, you're not going to see a lot of larger inlets, and second, we just don't think there are going to be a lot of sloughs drained as a result of this. I guess we'll see how that turns out. They felt very strongly that should be eliminated, that surface inlet issue. So all surface inlets are included. So this is worth noting. So again, 80 acres is still the permitting threshold, and that's what we came up with. SB 2208, which you've heard Jack mention a couple times today, that proposed that all projects be permitted, regardless of acreage. 2 acres would require a permit. So SB 2208, as a sort of a side note and my own editorial, that bill was decidedly anti-drainage, I think. And it's confusing to me why the legislature insisted that, not the whole legislature, Mark's here, for example, Senator Weber's here, he opposed SB 2208, and he's been a great advocate for water. I think we have some legislators who don't understand how important drainage is in our part of the state, on the eastern side of the state, for example. And that was just, it's frustrating to me. I don't quite understand it. But at any rate, I feel pretty strongly that 2208, in the form that it came in the legislature, and then in the amended form, was incredibly anti-drainage. And Cliff's going to sit on that 2208 committee. And we've been working together, Jack and Danny and Cliff and Kale and some engineers, on a slideshow to prepare for the 2208 study next week. But one of the things, like I say, we're facing is this anti-water resource district manager, anti-drainage sentiment, and we're trying to combat that. And again, I'm not quite sure why that sense is pervasive, but it is. But at the same time, the 2208 bill in its initial draft required permitting for all tile. So here, most of the bill is this incredibly anti-drainage statute or bill, but at the same time, it required permitting for all tile. Didn't make a whole lot of sense. But then in the debate for 1437, towards the very end of the session, last few days of the session, there's the huge debate about the under 80 notification that I'll talk about here in a minute. Some of the proponents of 2208, who had permitting for all projects. On the flip side, they were telling us, well, your notification requirement for under 80, that's a violation of landowner rights because we shouldn't have to notify the water board if we're tiling, you know, our a 50-acre project. So it didn't make a whole lot of sense to me there either. You wanted a permit for a 10-acre project, but then again, just a notification requirement is a violation of landowner rights. I didn't quite get that, but anyway, just a little editorial there. So like I say, I thought the bill was incredibly anti-drainage. Yeah, so the under 80 notice requirement, like I say, that was kind of the sticking point in the last week of the session. Jack and Danny were at all sorts of committee meetings and I don't know if they weren't official hearings, but that's where they ended up being. So there were a lot of debates about this under 80 notification requirement. And the reason it sort of arose was that Representative Schreiberbeck felt that it's important that the Water Resource District at least knows about the projects. Not because we're trying to report you to NRCS landowner. We're not trying to tell NRCS that you're draining your property. Not at all. That's not the point. The point is we have legal drains to manage, right? We have legal assessment projects to manage. We want to build new projects. So it's important that we know where the tile is. Number one, so we don't damage it, right? If we're expanding a drain or something like that. Number two, so we know where you're draining. So if it looks to us on LiDAR or something like that, yeah, sure, that water drains to the north or to the southeast. But if there's a tile project in there and it's actually going to the northwest and discharging out a culvert to the northwest, that's important to know, right? When you're doing a drainage assessment or something like that. So that's why Representative Schreiberbeck felt it was important that we have that under 80 notification requirement. That and a few other reasons. But so that was the big debate the last week. And we were all really nervous because, as Danny noted, there was language in there about the Water Commission cost share for drainage projects that was slid into that bill by the governor's direction. And so it was making us all nervous in the last few days. We were all really pleased that it went through and the under 80 stayed in place, but there's the sunset at the end of 22, I think it was. Again, I sure wanted that. Okay. So this just describes what the under 80 notification requirement includes. So if somebody comes in and says, hey, what do I need to do? I'm tiling 60 acres. What do I need to do? Well, first of all, there's a form on the state engineer's website. It'd be nice if they'd supply that, provide that form, fill that out and submit it. It's an exempt document. It's not, we're not going to send it to NRCS or anybody like that, right? You can't send it to NRCS. You can't send it to the state. I know you wouldn't do that anyway, but it's an exempt document. That doesn't mean you're going to be in trouble if somebody were to find out about it or anything like that. But just understand that it's just for your information as a water resource district. Ultimately, they can just notify the board through email or something like that if they want. It doesn't have to necessarily be on that form. I'm just going to kind of skip over these. I get up at 4:30 in the morning every day. By about 3:30, I'm kind of cloudy headed. So if any of you are ready for a nap or a beer or anything else, I get it. So I'll fly through some of this stuff. Okay, so let's talk about the actual filing process. Oh. Yeah, Dennis asked a good question. He's asking, what do we expect is going to happen at the end of the sunset when the under 80 notification requirement sunsets? What will be the next step and what do we expect? I don't know the answer to that, to be honest. I don't know what we think we will learn or won't learn. I still think the same rationale will exist, right? We're going to want to know about it just for purposes of assessment projects and things like that. I don't know if Jack and Danny have any insight on that, on the sunset. I wasn't there when they discussed the sunset or why they felt that 22 date was important. Maybe Danny can provide some insight on that.
basically the conversation was, there were some feelings on the Senate side that the notification requirement shouldn't exist at all. There were strong feelings on the House side that the notification requirement should stay as it was originally drafted, as a permanent requirement. And so the compromise was, we'll try it, but we want to make sure we have to talk about it next legislative session. So to force that conversation, they put a sunset on there, meaning it'll sunset, but it'll be timely for discussion with the 2023 session. So it was definitely a compromise between the two positions, but one that both sides could agree on.
Yeah, thanks, Denny. So we'll see how it goes and see if they take it up again or if they discuss it on this 20. Doesn't look like they're going to discuss it on 2208, but maybe. So the filing procedures, let's talk about that. So one of the things that the bill does is it requires a water resource district, the day that you get an application in the materials, that doesn't count towards your 3 days. You have this 3-day window to determine whether or not an application is complete. The day that you get it, that doesn't count. But 3 business days after that, let's say you get it on Friday afternoon, that day doesn't count. Saturday, Sunday don't count, not business days. Monday, you have Monday, Tuesday, Wednesday. You have those 3 days to determine, is the application complete? And I'll describe in a little more detail what a complete application is, but you have 3 days to make that determination. And if it's not complete, then you have to notify them. Now, the statute doesn't say how you notify them. What we've done is we've emailed people and we've called them just to let them know immediately. Look, hey, we need a downstream flow map. That's all we need. You're good, but that's all we need. And so it's a quick turnaround. 3 days is a quick turnaround. But I've seen a bunch of these permits applications come in already, and it doesn't take me long. So Steve's wife is the secretary treasurer for Dickey County. She just emailed me one yesterday. I glanced at it. It literally took me 3 minutes to glance through the documents and determine, yeah, they got everything they need. They got the application, they got the tax parcel documents, they have the project design map, they have the downstream flow map. Done. That was easy. So I think there was a lot of consternation initially when we were discussing this. Well, gosh, 3 days, that's really fast for a water resource district. And I understand that because at first glance it is, but you know, all you have to do is glance at it and you'll be able to tell pretty quickly whether or not they've submitted everything that they need. So, Cliff. Oh,
Let's say you meet every month, and this thing comes in 2 days after your monthly meeting, and you don't have an official secretary that checks the mailbox every day. Doesn't that put the water board in a very disadvantage?
it does, yeah. So I agree with you on that. And Dennis will remember, we talked about this at a legislative committee meeting. And we were saying, let's ask for 7 days. And that's what we asked for right away. And the response from, the ag groups and others was, here's what we're encountering from other water resource districts. They sit on these things for a month. They don't ever tell us if it's complete or not. We wait till the next water board meeting. This is a long-winded answer to your question, Cliff. I'll get there. You sit on these things for a month. You don't even tell us if it's complete or not, if we're missing anything. Then we get to your next water board meeting and you sit there and you tell us that it's not complete. Come back to us with X, Y, and Z. So that was the rationale that we heard. Your problem there, Cliff, that you just described, that's a problem. I totally agree with you. So what we're going to have to do is you're going to have applicants submit them. If you don't have, you're going to have an office, right? A registered office. All water resource districts have to have an official office, right? An official mailing address. What's your official mailing address? You know, you're gonna have to figure out what that's gonna be. We make sure everything goes, for example, I keep bringing up Dickey County Water Resource District because for a long time, the secretary treasurer for the Dickey County Water Board was Hope Jury. She operated out of her kitchen, you know, and that's exactly that type of situation. Hope was very active in terms of ensuring that she was checking her mail because she was the official mailing address. She checked her mail, she got emails, things like that. It puts a lot of pressure on you as water resource districts. I totally understand that. We just understand that on the other side, they were saying, we need a window and it's got to be short. And here's why. And the argument is there are water resource districts who weren't acting on them. They weren't telling applicants whether or not they were complete applications. So to answer Cliff's question, yes, it puts a lot of pressure on boards. You're going to have to figure out a process so that you review these things quickly when you get them. Yeah, Dennis. Right. So it's not defined in the statute. To me, it's most likely, though, it's when they deliver it. So again, it's a pretty quick turnaround, obviously, and it puts us in a tough spot. I totally agree with that. Again, this bill didn't end up, from our perspective, it's not perfect, right? But that was a negotiated point. So.
I think that 3 days though is just to define it complete.
Right, just to define it complete, not to say it's.
You have that 33 days, 30 days after that 3 days. So I mean, if you.
No, 30 days, it's a 30-day window from the day you receive it, yeah. But if you decide within that.
You could request it.
Yeah.
And hopefully it'd be nice enough to give it to you. I mean, if it's like one map or one piece of information that's missing off of it.
Yep.
That's just the 3 days to just essentially.
Yep.
Before it's automatically deemed a complete application.
Yep. No, that's right. So, yeah, this places a big burden on water resource districts. I totally agree with you. But we also heard a lot of horror stories that Levi had encountered where a certain water board or somebody, they'd get an application, they'd sit on the thing, and then they'd never hear if it's complete, and then they wouldn't get the project approved. Yes, sir. So, yeah. So right. Right. The question is, basically, I think, correct me if I'm wrong, but I think the comment is, the spirit of the law is make sure you get the thing reviewed. Just because you haven't, let's say, for example, your secretary treasurer is out of town for a week. Okay. Let's say that happens. It's going to happen. And in fact, it'll happen with some of the boards I represent. If I go on vacation for a week, God forbid, right? If I go on vacation for a week and somebody sends me an application and I don't review it until the following week, if somebody's missing their tax parcel information, for example, it's outside the 3 days, but I don't care. I'm just going to contact the applicant and say, hey, yeah, we'll approve this at your next meeting. All I need is the tax data. They'll still give it to me, right? It's not the end of the world. So this 3-day window, it sounds scary. It's not. What are they missing? The most important thing that you need is going to be your project design map and your downstream flow map. And let's take, we keep talking about Levi and his company. Those guys, I work with them a lot. And if they're missing a flow map, they're going to get it to me. It doesn't matter if they're outside the 3 days. You know, they want this thing to go through, and they're not trying to cause headaches for you. So if you don't see it, if I'm on vacation and I don't see it until I get back, and it looks like, oh, they're still missing their downstream map, that just means that I'm going to email the agent working for Ellingson and say, hey, could you send me a downstream flow map? Board meets next week. Yep, here it is. You know, it's going to happen. What's the worst thing that can happen? They don't send you the downstream flow map and then you have to approve it. Yeah, that could happen. And then you're not going to know who to give notice to downstream. Yes, that really actually could happen. If I'm gone for a week and a contractor submits an application for somebody and they don't include the downstream flow map, that could be a problem. I mean, we really could run into that. I don't think it's with Levi's company, it's not going to happen. Those contractors, those guys know what they're doing. They want to provide us the information that we need to get those things approved. If it did happen, then you're going to have to do a little bit of footwork on your own. All right. And I've had to do that several times before this bill went into effect. But sometimes you got to do some footwork to find out who's a downstream landowner for a mile, right? We may have to do a little bit of footwork. But the 3-day window seems ominous, but it's not a huge deal. Okay. Just make sure you review the thing when you get it. It'll take you 3 minutes to look through the docs. Yep. Okay. Application signed. Yes. Tax parcel data for the property they're tiling? Yes. Tax parcel data for the property downstream? Yes. Project map? Yes. Downstream flow map? Yes. Pretty quick, pretty easy. So 3-day window, not great, right? It's not perfect bill, but it meets the needs for the applicants, and I think for the tile contractors who are running into situations where water boards aren't reviewing these things and they're not telling them what they're missing. So that was a real problem, and again, it's a negotiated bill, right? It's not perfect from all perspectives. And again, I'll talk about what a complete application includes, although I just gave you a brief description. Okay, application fee. Levi touched on this a little bit earlier. So it was $150 prior to this session was the max. This bill increased the max to $500. Couple things. The permit policy documents that I've drafted as a result of this bill, it contemplates receipt of a $500 permit fee, but with the idea that any dollars you don't use, you'll refund to the applicant. Now, that's not required under the bill, but a couple of senators late in the session made it clear that they wanted to see water boards do that. And it's been interesting, you know, over the last 10 years, there's been some suggestion that water resource districts are getting rich off these tile permit fees, right? And I know, yeah. So you guys all laugh because you know that that's ridiculous. And there's also been a suggestion that Fredricks is paying for his kids to go through college with tile permitting. I'll be honest with you, if I never had to look at a tile permit application again, I'd be happy. But I do them because I know they need to be done right, because applicants need them done right, okay? Downstream parties may come after you. Water boards need them done right. Okay, you don't want to get sued, or you don't want to be appealed, you don't want to be in court because you didn't do something right. And so we want to make sure that these landowners who are coming in, that they're getting their permits done properly, that we're having good project descriptions, so that that's another quick side note. Like the notice of decision, for example, that we send out, or in the minutes, we have a very detailed description of what the downstream flow is going to be. And you might say, well, you already get a downstream flow map. A lot of you probably know that, you know, a lot of those maps, downstream flow maps, are plat books, right? Somebody copies a page out of a plat book. They take a yellow marker, and here it is. There it is. There it is. Well, you look at those things and you say, well, which side of the road are you on? And is it crossing through this culvert or this culvert? You can't tell from those things, right? So we do a very detailed downstream project description, including the downstream flow. And the reason we do that is 10 years from now, when the downstream landowner sells his property to John Smith, John comes into the water board and says, hey, this water is draining over my property. I'm filing a complaint. So you get a complaint. Now what do you do with the complaint? Well, you look at the permit and you got the downstream description, and it says, oh yeah, sorry, Mr. Smith, it says right here, we approved this permit, and it said that it was gonna flow through that culvert. And we issued a notice of decision. We sent it to you, the person who owned the property before you. We sent it to the state. We followed the statute. Complaint dismissed, okay? That's one of the reasons that we go to that kind of detail. And so it takes a little time to do that. And so, like I say, these permit applications are not a way for your water resource districts to get rich. You're not throwing parties with these dollars. I'm certainly not paying for my kids to go to college with tile permit fees. So the $500, as Levi put it today, look, if somebody's putting in a $200,000 project, a $500 permit fee doesn't seem unreasonable. Now, at the same time, be smart, right? Don't take in $500 fees, and let's say your secretary treasurer does it all of the review, all the documentation, everything. I know that, for example, in Richland County, Monica does a lot of it right now. And I think they came up with a fee schedule with a couple $100, I think.
Yeah, it's $200 right now, depending on in the future,
Right. So Richland County charges $200. Monica spends a lot of time on those applications. I know that she does. And she's in there on Saturdays working on these things. So, I mean, she's putting in a lot of time. For me, the average is probably about for one of us, it's probably about $500 to go through it, review the application first, draft up the notice, send it to the state, that kind of thing. It probably averages out. That's probably what it averages out to be. So we want to make sure that your general fund is not taking a hit, number one, and we want to make sure that we get these things done right, number two. And so that's the idea. But the permit fee policy documents that I've drafted, they say $500 max, but we're going to return anything we don't use to you as an applicant. So that's what I recommend. Yes, sir. Yeah. So the comment was that lawyers are rich money grubbers, money grubbers. Like I said, and Cale and Jack can probably back me up on this. I do not want to be sitting on my desk writing out tile permits for my practice. That's not what I envision as my practice, right? But I do it because it's a service that we need to provide because you guys need to do this right as water boards. You have to do it right. And it concerns me that some boards don't do it right and that you're going to get sued or you're going to be in court because of it. Or an applicant's going to be upset with you or a downstream landowner is going to be upset with you and they're going to talk to your county commission and they're going to talk to the legislature. You got to do these things right. Okay. So again, we're not trying to get rich either. Trust me. And it's not making me rich. I guarantee you that. My son's going to a state school next year. So he's not going to an Ivy League school or anything like that. So. All right. Sorry, I got to look at these things. I can't see it without my glasses. Oh, so the 30 days that we talked about now. Okay, so you got 3 days the moment that it comes in to determine whether or not it's complete. Then if you determine that it's not complete, notify them immediately. Let them know, hey, we need the flow map. Once the flow map comes in, let's say it's 2 days later. When that comes in, that starts your 30-day clock. So you have 30 days from then to approve that thing. If you don't approve it within that 30 days, then it's just considered approved without any conditions. So you might say, well, why do we care then? Why don't we just leave it and it'll just be automatically approved? Well, the reason is because you have some conditions that you can attach if you want, if you're so inclined, if you feel that it's necessary. That's why you want to process these things. Plus, it's your job, right? I mean, you're North Dakota farmers, most of you. You want to do your job. But also because there are some conditions you might want to attach. Let's say it has a pump on it. We'll talk about permissible conditions. Let's say there's a pump on it. You have the right to attach a condition that says you have to turn off your pumps if there's flooding downstream. That's an important condition that you might want to attach. If you don't act within 30 days, then it's deemed approved without any conditions. Okay, so let's talk about the 30 days thing, and Dennis and Jack will remember that we talked about that too. Well, that's a pretty quick turnaround also. And let's take the situation that Cliff mentioned. Let's say you were in the middle of planting. So maybe maybe smaller water boards, maybe they don't meet. When I say from smaller, I mean from more rural counties. Maybe you don't meet every 30 days, especially during planting or during harvest, right? Maybe you say, well, let's take next month off and we'll meet the following month. Well, you only have 30 days to approve one of these things. And so you're going to have to meet. And some boards that don't meet, that's caused a problem. Okay, and that's what we heard from some of the ag groups, and Levi explained too in our discussions that, look, some of these water boards don't meet, sometimes 3-4 months at a time. And if let's say you're an applicant and you submit an application and you've got, and let's say you're Ellingson and you have tile ready to go, and you're just sitting there waiting and the water board doesn't meet for 4 months. Okay, so that's a problem for a lot of different people. And so the 30 days might seem like a bit of an issue, right, for water boards who don't like to meet every month. I understand that completely. But I also understand the other side of it where applicants are saying, yeah, but I'm not getting my project approved for 4 months. That's not fair either. So you understand that argument too, right? So, what's the way around it? Well, calling a special meeting isn't hard to do. You can all call in from your combines if you want, as long as your secretary treasurer or somebody has a phone with a speakerphone. You can do a quick special meeting as long as you go through the procedures for a special meeting. Yeah, again, some people weren't too happy about this requirement, but again, you got to understand also the concerns of applicants and tile contractors who are saying you can't just leave us sitting out here for 4 months. And you certainly understand that. On the flip side, water managers, we have to understand that we got to get these things done. So it doesn't mean you all have to get out of your combines and come into the courthouse. Just do a quick special meeting. It's pretty easy to do. It really honestly is. And now with Zoom meetings and stuff like that, you could be sitting in your combine on your phone doing a quick meeting, right? So it's pretty easy to do. Take you 5 minutes and do a quick special meeting. But you got 30 days from the date that you receive a final application, a completed application. So make sure you meet that because you're going to want to attach some of those conditions. I'm yammering on here like a long-winded lawyer, so I'll try to run through some of this a little faster. So we eliminated the 30-day notice process, and I just want to discuss this piece and then one of the conditions that we can attach as a result. We were finding that I think as water resource districts, probably as landowners, as ag groups, as tile contractors, that was not accomplishing much. And I think the idea was, I think the sentiment was positive, right? The idea was, look, we got to notify downstream parties that this project is coming. And if you have a problem with it, bring in your technical evidence that it's going to damage you. And that all made good sense at the time because you felt like it's given a downstream party an opportunity to voice opposition. And that made a lot of sense. But what we were finding is not many people were taking advantage of that. And the few people who were hiring engineers, and it had to happen quickly. So let's say if I got an application, it's from the date that it's filed. So let's say it was a Friday, the scenario I talked about earlier. And then you don't get, let's say the secretary doesn't see it till Tuesday. Well, you've already missed 5 days, the downstream party. Then you got to get the thing sent out, and it's got to be by certified mail. So then let's say the downstream party doesn't sign for it for another 6 days. Well, then they only have whatever it is, 15 days left to hire an engineer maybe, submit their technical evidence for the water board to consider. I mean, it was just a hassle, right? And it was expensive, and it was taking everybody's time. Whereas applicants were saying, why are we waiting? Well, we have to wait 30 days because they need to be able to have the opportunity to submit technical evidence to object. The people who are actually doing this, they'd bring in an engineer, the applicant would come in, and then who's stuck is the water board, and a lot of times their engineer, to decide, okay, is this really going to result in adverse impacts downstream? Hatfield-McCoy issue again, right? So it wasn't really a fruitful exercise. And we just found, I think, all the way around, we just felt like it's just wasting time and it's wasting some money. How else can we address downstream impacts without going through this kind of ridiculous process? So we all agreed, let's eliminate that. Let's get rid of it. It just costs extra, it results in extra costs, and it's a 30-day time delay. So we all agreed, let's just get rid of it. And we came up with a condition instead to address downstream impacts that you can attach, and that I think is really meaningful, but it's not one that you can just attach haphazardly. So I think we came out with a pretty good condition. I'm gonna whip through these here so everybody can get to the bar. Yeah. Okay, so this is the condition. All right, so what did we decide instead? Who are the people that could be impacted from a tile project? It depends on who you ask, right? Some people might say there are no impacts. Some people might say, well, every single road ditch, if you discharge into a road ditch, that tile project is going to damage the township road for sure. It's going to kill our foundation of our road. You know, where the downstream party might say, well, I'm going to have saline water. I'm going to have cattails in my ditch. It just depends on who you ask. And so we all agreed 30-day notice situation gone. Easement notice, we don't want, or easement requirement, we don't want that either. We don't want to say, water board, you have the power now to require the applicant to get an easement from a downstream landowner. We've gone through that before. It's not helpful. Hatfield-McCoy situations. Water boards don't want to be in that situation where you're requiring an easement, and you know by doing that, you're killing the opportunity for the applicant to install the tile because the downstream landowner isn't going to grant an easement. They're never going to sign it. So it was it was not a good situation under either of those scenarios. So what else could we come up with? So this is the point that took the longest to negotiate. Let's come up with a condition that a water board can attach that's meaningful, but that water boards can't attach haphazardly, or at least that downstream landowners can't use in a manner just to oppose a project without demonstrating some kind of impact. So we came up with some language that says a water board can attach a condition that says if your project results in directly causes damages is what I should say, directly causes damages downstream, then you can require the applicant to remove silt, repair the damages, and it could be a downstream road authority or a downstream landowner, but it's got to be directly caused by the outlet. Okay, so that's a pretty significant standard that you have to meet. And again, it's only up to 1 mile, and the moment it hits a legal drain or a natural water course, that requirement ends. So let's say if the project outlets directly into a legal drain, for example, you can't attach that. Or if, let's say it discharges into a township road ditch and it flows for half a mile, then enters into a river, then you can attach it for the half mile, okay? Okay, so again, it's not something that the downstream landowner can take advantage of either to kill the project. They have to come in and prove with substantial evidence, this is in the statute, substantial evidence that your project applicant, that your project directly caused, silt or erosion or damages. Substantial evidence that you directly caused it. So this I think was a good negotiated outcome that we talked, like I say, we talked about this on our committee with Representative Schreiberbeck for a few months, actually. This was the biggest sticking point because as water resource districts, we felt like, hey, we're doing this balancing act. We want the applicant to get his or her tile project approved. We also want to make sure that the road authority and the downstream landowners have some sort of remedy if they're impacted. This is what we came up with, all right? Downstream party, you feel like you've been damaged, come prove it to us. You have to present substantial evidence that the project directly damaged your property. Okay, that's not an easy standard, so it can't just be Hatfield-McCoy stuff. It can't be coming in saying, they're damaging my property. Well, how are they damaging it? It's more water. More water. That's just not enough. You need substantial evidence that it's directly damaging your property or the road or whatever it is. So it's not an easy standard to meet, but at the same time, it does afford downstream landowners and downstream road authorities some ability to protect themselves and come into the water board. So that was the biggest takeaway for us as water resource districts that, okay, again, we've got all these different interests we're trying to balance. We support tile. We also have to support our road authority partners. We also have to look out for interests of downstream landowners. This is the language we came up with. I think we've struck a pretty good balance. Now we'll see how it works out. If somebody comes in and files a complaint, we got to see how a water resource district reacts. But I felt like this was a pretty good negotiated settlement in terms of how we balance all those different interests. Any thoughts about this? Any complaints? It's too late now, it's in effect, but any complaints, any thoughts?
Yeah, I guess for Richland County, I guess if there is a downstream landowner that is concerned, essentially we just tell them to take a picture before and then after.
Yeah.
Take a picture every week or however you want to do it. If you're concerned about something, pictures of stuff would be great.
Yeah, so Justin's point is, what the Richland County Water Board is saying is they're telling downstream landowners, look, if you're concerned, gather data up front, take some pictures, do whatever you think is necessary up front so that later you can prove that it's causing damage. Cale, what do you think? I mean,
Yeah, I think when this was being talked about, and I asked the question, well, we need some examples of where this comes up. What I heard most consistently was, as Levi mentioned, maybe a lateral pulls away from the main and it gets filled with sediment and then causes a big moving downstream. In most cases, something to that degree, most landowners are going to look at that and go, oh, I know why that's there, I caused that. They're going to do the right thing. I'm just hopeful that,
Yeah, I agree with Cale's point there that I think in most instances, if there's an issue where somebody's caused some damage, it will be resolved and it won't end up in litigation. But again, if it does, I think the language balances a lot of those interests pretty well, and it's not an easy standard to meet, and you can't just come in and be ticked off at your upstream neighbor and get his project shut down. It just won't happen that way. But if let's say you're the road authority, let's say Jason says, hey, this project is ruining our roadbed, and he has evidence to demonstrate that, he can come in and we can address it. So I do think it was a good balance that we struck. And once again, I've long-winded lawyer talked. So, all right, I didn't get through all of it, but we're already done. So I noted earlier that Jack sent out some sample documents that I'd put together. If you want those, let me know. I'll give them to you. I'm not going to charge you for them or anything, right? Those damn lawyers. If you want samples, I'll give them to you in Word. You can modify them all you want. Cliff, I think, had his hand up. You bet.
When you're providing this information and pictures about downstream damage, what was the damage before
Yeah.
it was installed?
No, that's right. I mean, Levi was, when we were talking about this, he was pretty adamant that, look, you'll be able to tell pretty easily when you look at this. Is this really, truly, you can look at the outlet and you'll be able to tell. But Cliff's point is, how can you demonstrate, the direct damage? So I think that's a good point. Just sorry, Justin, one last point I want to make is that the project map that they submit with the application, there are two maps. One is a project map, right? That's your pattern tile map. Then you have a second map, that's the downstream flow map. The project map that you get, that's an exempt record. Do not send that to anybody. When you send notice of your permit approval, don't send that project map. Don't send it to the state, don't send it to downstream landowners. That's an exempt record. Yes, Tom.
What is the purpose of that?
So yeah.
Section of where the outlet is. Why do we need to know each one of those little lines?
Oh, I thought you were talking about the exemption. What's the purpose of the exemption? Why do you need to know? Because again, the downstream landowners, you got to notify them. So one of the negotiated points, we got rid of the 30-day notice piece, but we at least have to notify the downstream folks after you approve it. That's why you have that downstream map. Oh.
With the exception of where the outlet is.
Why do you need to know where the pattern tile is and where the outlets are and things like that? That goes to the point about if you're building an assessment drain, for example, or if you're trying to figure out who should be assessed where or what the benefit is to the northeast quarter of section 12 when you're assessing a project. You got to know where it drains, right? And that kind of thing. And so that's the point of the project design map. But it's an exempt record. Do not send that out to other folks. Again, I'm sorry I rambled on here so long. I didn't get through everything, but, Rich, yeah. Yeah, certainly, yeah. You bet. Yeah. Yeah, I've got checklists. I've got sample docs, list all the conditions. Anything you want, just shoot me a note or, call me or whatever. I'll get it to you. I'm not, like I say, I'm not going to charge you for that stuff. Just let me know. Yes, sir. They didn't take a position. They were concerned about a few things. They helped us with the exempt versus confidential record thing. They helped us through a lot of it. They had some concerns, like I say, but didn't take official position on it. Hey, thanks everybody. Thanks again to Jack and Danny.
Yeah, thanks, Sean. It's strange that the three lawyer presentations went over today.
There are some keys left.
If anyone's missing their keys, Julie handed these to me.
Anybody missing?